All right. Thanks, Thea. Hello, everyone. Excited to be here today. Really looking forward to this topic. We're talking with Sarah earlier. I think this is going to be a great presentation. This is one of those timely topics that seems to always be at the top of drafting the MSA is always one of those things that we all have to know about with mediators. By way of some background on Sarah, Sarah E. Saltmarsh has been a practicing attorney for 34 years. And is a member of the State Bar of Texas and the Florida Bar. She practices family law, collaborative law, and mediation. She's been board certified in family law since 1992 and is AV rated by Martindale-Hubbell since 1996. Sarah has served as an adjunct professor at the University of Texas School of Law and is current chair of the ADR section of the Austin Bar Association. She's also first vice president of the Austin Collaborative Divorce, past chair of the family law section of the Austin Bar Association, past chair of the women's law section of the Williamson County Bar Association, and an active volunteer in the Austin Bar Association, Williamson County Bar Association, Hayes County Bar Association, and the Austin community at large. We're thrilled to have Sarah here. Sarah, I'm just going to kind of turn it over to you and let you take it away. Thank you for being here.
Thank you so much for the introduction, and I really am delighted to see so many faces of people that I don't know, which is really exciting. I mean, you kind of practice within, although we don't have practice groups exactly, you tend to see the same mediators regularly, and there are a lot in this group that I don't know. So I'm really pleased to make your acquaintance, even though it's by Zoom. And since once I get into the PowerPoint, I won't really be able to see you, to kind of see the full gallery. I wanted to ask if you would literally just raise your hand if you are a non-attorney mediator, so that I can know that. Okay, thank you. And is there anybody in the group that has mediated less than, say, 10 cases? Okay, so most of you have been mediating for a while. I'll tell you just briefly that I have mediated for almost 30 years. I have mediated since the inception of Settlement Week in Travis County. And I was trying to think of when that first Settlement Week was. I believe it was in 1989 or 1990. But at that time, very few people had actually been through formal training in mediation. There were not a lot of mediators in Austin, and so there was I guess the Bar Association must have put that on, but we had a training for people who were going to mediate during Settlement Week, and that was when I first went and first started mediating, originally just with Settlement Week, and then of course did my full training in my family law training. I've mediated a variety of cases, but most of the time people come to me for the family law cases. And Steve, in asking me to speak today, asked for a bit of an emphasis on family law. So that is the emphasis that I have on my presentation today. However, the case law, much of it is going to be applicable to any sort of case. Anyway, so and let me put in one more plug for, I'm chairing the ADR section of the Austin Bar for the third year. I've served on that board, I think it's about 5 years now. When Judge Crump was the president of the ADR section, I think is when I joined that board. But if you are an attorney mediator and are not in the ADR section, I really invite you to join that section. We also try to have a very active CLE program. And I've been working on 2 pet projects when I've been chairing the ADR section. One, I hope you might have heard of, it's the Courthouse Mediation Project. And we started that, and we were into it, I guess, maybe as much as certainly at least a year, I think possibly a year and a half when the pandemic hit. And so we haven't been able to do it, but we were mediating on 2 Fridays per month for free, just volunteer mediation in the morning at the family law docket. And that had been going, very well. It's something I'm very interested in continuing once we have, live hearings again, and we can do it meaningfully. And the other thing I've been working on that some of you all may be interested in too, is bringing back our settlement week to Travis County. We still have 2 calendared weeks per year on the court docket for settlement week, but we're not actively having it anymore. And there's apparently quite a backstory to all of that, but I know the last one that I mediated at the courthouse, they were having a lot of spatial issues, not enough room to assign people or to give people caucus rooms. And then we tried doing it with the participants connecting with their assigned mediator, by email or phone, and that didn't work particularly well. So anyway, bringing back Settlement Week, one of my projects, and now that we've all had to learn Zoom or some other teleconference platform for mediation, that might provide a solution to the spatial issue. So if you're an attorney mediator and have an interest in the Settlement Week reinstigation, if you can shoot me an email, I'd love to have your interest and participation. And my email is Sarah, S-A-R-A, @saltmarslaw.com. And I'm going to go ahead and jump into the PowerPoint I prepared for today, and we will try to leave some time at the end for questions. So I'll see if I can try to do this smoothly. All right. Well, hopefully I'm up, and I've got just my title page here now. So we're going to just kind of move through this. And what I wanted to do is I've got some cites to the mediation statutes that are applicable for us. And the first slide is about the cite to the Texas Civil Practice and Remedies Code. And this came into effect in 1987. And it is simply establishing mediation as a forum in which an impartial person, the mediator, facilitates the communications between the parties to try to promote settlement. And also states that the mediator may not impose his or her own judgment on the issues for that of the parties. Texas Family Code, section 6.602, explains the mediation procedures. And this statute is exceedingly important because when the courts are looking at whether an MSA has complied with statute, they are time and time again coming back to 6.602B, whether the mediated settlement agreement provides in prominently displayed statement that is bold-faced typed or capital letters or underlined that the agreement is not subject to revocation, is signed by each party to the agreement, and is signed by the party's attorney, if any, who is present at the time the agreement is signed. This little list is pivotal in the case law, and you'll find, as you probably already know, that the courts will basically bend over backwards to try to enforce MSAs. And because I still have a litigation practice and do litigation, collaborative law, and mediation, I do have the benefit of actively being in mediation as one of the attorneys for the parties, which adds to my own mediation practice as I see what other mediators do effectively, continue to keep up with what the courts are doing, so have some sense of what would happen to this case if it were in the courtroom and not in mediation. And I think that is one of the reasons sometimes that people do come to me, is that I have a lot of years experience and I have the trial experience in addition to the mediation practice. But this checklist in 6.602 is just all important. And I'm sure all of you are doing it. If you've been mediating for a while, you have your forms in line, and some people have all of these things, bold-faced, capital letters, and underlined, that it's not subject to revocation. Okay. And again, because I was asked to put somewhat of an emphasis on family law mediations, I have the reference to section 153.001 of the Texas Family Code. stating that the public policy of the state is to assure that children have frequent and continuing contact with parents who have shown the ability to act in the best interest of the child, provide a safe, stable, and nonviolent environment for the child, and encourage parents to share in the rights and duties of raising their child after the parents have separated or dissolved their marriage. This code site comes into play sometimes with relocation cases. And if you all have ever mediated those relocation cases, when one of the parents wants to move with the children, are sometimes more hotly contested and more protracted than the original divorce or suit affecting the parent-child relationship was. And this public policy is often stated as the resistance to the move is that it is the policy of the state that the children will have frequent and continuing contact with parents. And obviously those rights and ability of the parent who doesn't move are greatly affected by a move. So this policy is cited frequently in the relocation cases. And I do wish the Texas Supreme Court had updated these ethical guidelines. Some people maybe are not even aware that they're out there, but there are ethical guidelines for mediators, and I've cited in the slide the website where you can pull the whole all the guidelines if you'd like to just have those in your own directory. But I pulled particularly section 12 out because this is it focuses on an area that is, I think, an area of some ethical debate, actually. And that is whether, and I've highlighted this language about the role of the mediator, and that the mediator should not be serving in any sort of judicial capacity after mediating. But then the guidelines say, notwithstanding the foregoing, where an impasse has been declared at the conclusion of a mediation, the mediator, if requested and agreed to by all parties, may serve as the arbitrator in a binding arbitration of the dispute, or as a third-party neutral in any other alternative dispute proceeding, so long as the mediator believes nothing learned during private conferences with any party to the mediation will bias the mediator or will unfairly influence the mediator's decisions while acting in the mediator's subsequent capacity. This is an interesting provision from an ethical standpoint, and they are appropriately ethical guidelines. But in many practice areas, I know in construction law, for example, they often do med-arbs where the parties and the attorneys are expecting that if they can't mediate the case, that the mediator then switches hats to arbitrator. It happens less frequently in family law. It happens most often with construction of language, just interpretation of, I guess, the translation of the MSA into the longer decree or SAPSR order, that the mediator often agrees to arbitrate issues that involve drafting, but sometimes the mediator agrees to arbitrate any dispute that arises out of the MSA. And some of the cases I'm going to be talking to you about discuss that issue, that parties have agreed to it, and they've agreed to the arbitration. Now, several issues arise, I think, with several considerations that I'd put out there for you to think about with your agreeing to be an arbitrator. Say, for example, you have already presented an agreement to mediate, and you've already drafted your cover MSA. And a lot of you may do, as I do, I have kind of a standard MSA, just a 2-page agreement, and then I attach the substantive exhibits. It could be A, B, C, D, it could be more, might be a spreadsheet, could be a list of property, a variety of things that end up getting attached to it. But I tend to have pretty much form language in my MSA. But when I am representing a party to mediation in particular, I look at this really carefully, because sometimes I may go to a mediator that I like, but I would not necessarily want to arbitrate disputes. And other times I'm really comfortable with the judgment of that person. clients are relying really heavily on their attorneys because the attorneys are the people selecting the mediator, not the clients, in rare instance, unless of course they're pro se. So a lot is being put on the attorney to make sure that the client is adequately advised. And I believe there is a duty to advise the client that when they're agreeing to binding arbitration with the mediator, they are forfeiting their right to an entry of judgment hearing. And then the other thing that comes, I think, immediately into play with this language is what sort of thing might the mediator have learned that would really influence his or her decision to serve as an arbitrator? Because it's perfectly permissible, even if you have a standard form and the attorneys have agreed to it, if you finish a mediation and you feel like, you know what, I just don't like one of these people, maybe you don't like both of them, or that you feel anything you've heard would just make it very hard for you to be neutral, I think there's a duty really to tell the attorneys or the parties that you don't feel you could serve as an arbitrator. And there's nothing wrong with doing that, and there's nothing wrong with changing the language. But I do urge you to think about that. Many times I think the clients are not advised about the importance of what they're giving up if they choose to go to arbitration. And when I go to mediation with my own clients, sometimes the mediators, the clients just love the mediator. Other times they don't, and maybe they wouldn't want to, arbitrate the case. So until everything is signed, you can always change things, you can modify it and make it selective. But I do urge you to think about this issue: is it always appropriate to serve as arbitrator if you have served as the mediator? It's an interesting ethical issue. Okay, so what happens if MSAs, if there are disputes about drafting? Many times, again, the mediator has agreed to arbitrate disputes, particularly over drafting issues. And there can sometimes be an issue: is something a drafting issue or is it a substantive issue? And I can give you an example of one of the issues that came up in a case of mine that did go to arbitration with the mediator. Was it had to do with summer possession schedule. There had been a protective order in the case, so the parties did not get along. Father was very threatening and intimidating to the mother. So there really needed to be clear boundaries. And in the mediation, the summer possession for the father was if he gave notice by a certain date. There was no agreement to any sort of default summer. It was not a family law practice manual or standard possession order at all. It was a completely different type of schedule. And so when we drafted the agreement, I had no default language for summer. And father's attorney objected to that. That got arbitrated. The arbitrator ruled for us on that. And we entered the decree. Well, lo and behold, a few years later, father missed the deadline, filed another motion with the court, really erroneously doing a contempt because he made a late designation. The court again upheld the language of that order. But one person could potentially argue, well, the default possession schedule, that's just a drafting issue. Our position was, no, it's not. It was a substantive issue, and it was an issue in a case where it was very important for people to have boundaries. So there's that little fine line for what if it's not a drafting issue, then you have a motion for entry with the court, with the parties debating, what should be in the MSA, unless they have agreed to go back to the mediator on all the issues for binding arbitration or for continued mediation. I'm citing the Lee case, which is an interesting case. I think the main holding from Lee is that the trial court may not deny a motion to enter judgment on a properly executed MSA based on a broad best interest inquiry. And the court was going through, again, the properly executed MSA. Was it irrevocable? Did it have this in bold-faced letters? Was it signed by both parties and their counsel? All those little check marks that the court went through to say, yes, the MSA was properly executed and it would not overturn the MSA. So this is interesting because the broad best interest inquiry, what had happened was that when one of the parties went in, which I think was the father, to have the court render judgment on the MSA, they went to an associate judge. And for some reason, because the mother was married to a registered sex offender, and the MSA had a lot of carefully negotiated provisions for protecting the child, like a stay away distance and notification of the type of car this person had, and a variety of things that have been clearly, carefully negotiated. But at the prove up, when I guess one of the parties said that there was a registered sex offender involved, and then made a pretty alarming statement to the court that the sex offender was sleeping naked between his child and the mother, the associate judge then refused to enter judgment, finding that probably rather alarming at the least, and held that in the best interest of the child, he couldn't enter the judgment. So the Lee court, which was a Supreme Court case, it went through the analysis about best interest. And you'll see that the court said, we certainly do not hold that a child's welfare may be ignored. Rather, we recognize that Section 261.101's mandatory duty to report abuse or neglect, the numerous other statutes authorizing protective action by the trial court, and the safeguards inherent in the mediation process fulfill the need to ensure that children are protected. And they do so without subjecting MSAs to an impermissible level of scrutiny that threatens to undermine the benefits of mediation. So the court could not substitute a best interest inquiry for the judgment of the parties in entering into the MSA, and it was upheld by the court. And the Lee court went on to discuss a number of things, but it also spoke to the encouragement of mediation in high conflict custody disputes, and really states the policy of the state to encourage peaceable resolution of disputes, with special consideration given to disputes involving the parent-child relationship, including the mediation of issues involving conservatorship, possession, and support of children. And so, as mediation has been used now for decades, several decades at least, there is now quite a body of case law that has arisen about MSAs, and it's certainly, in looking at the case law in preparation for talking to you all today, there's just a lot more out there than there was when we first started out. And time again, the court will try to, and does, enforce the MSA. And it's very, very difficult to undo it as long as those requirements have been met, that kind of magic checklist that you've got to have in your MSA. I wanted to talk a little bit about what people have done during the pandemic, as we've had to adjust to mediating by Zoom or WebEx, or I think there are a variety of teleconference platforms out there. But for people like me, and for probably many of you who have been mediating for a lot of years, it's been difficult making the adaptation, because I'm very used to having that, trying to establish a rapport with the parties, trying to establish a rapport with the attorneys, that I think is much easier when we're live. Nevertheless, we've had to adapt in order to keep the process moving forward. But I still, when I am the attorney participating in a mediation with my client, I usually try to get the client to come to the office, even during the pandemic, just so that that relationship is there, that kind of bond that you're forming as a team. Many of you probably have a little, whatever has worked for you for the years as a way to break the ice. Many people, I always try to have nice snacks and things like that. I enjoy baking is one of my hobbies, so I usually try to bake something. And one of the people that I often mediate with has a garden, and she often brings some fresh vegetables to people, and just ways to establish a little bit of a personal connection. So now that we're in Zoom and other forums, we have to figure out how to get people engaged in the process. It's a lot easier, I think, to kind of shut down when you're talking to a screen and you don't have that closeness of a real person. So what I have tried to do when I'm mediating, and I've also requested in appropriate cases from the mediator, I want to meet my opposing attorney. Um, and some of you, if you do litigation at all in addition to mediation, I'm now at the point with clients where I've never met them in person. I had a initial consultation by Zoom. We've gone through the whole case. I've talked to them on the phone, of course, maybe had subsequent Zoom meetings. We're closing out the case, and I really wonder, would I recognize this client on the street? And it's a loss, I think, because with the type of work that I do, being pretty much exclusively family law at this point, there is a certain intimacy, there's a certain bond that forms when you are representing the party. And you don't have that when you're just in a breakout room and they're in another location. And I think it's hard for the mediator too to kind of establish that rapport. But in a very successful mediation that I had with a local mediator in January, and I was representing one of the parties, not serving as the mediator, he had a great little meet section at the beginning where he had the attorneys in a breakout room. None of us had ever met each other personally. Excuse me. I was dealing with two much younger lawyers who had practiced for a lot fewer years, and so I'd never met them in person. Just spoken to on the phone. So the mediator held this little meet and greet with us, just the attorneys in a breakout room. And of course, when you do that, you need to be aware that nobody gets sideways or that the meeting, becomes unfriendly. Excuse me, but it was a great way. It was a great way to meet the other person and break the ice. And the mediator asked me, for example, about my children. And he knew I'm super proud of my child who's graduating from law school. So that gave me a great opportunity to do kind of the mom's brag thing, parental brag thing, with talking about my child, making me feel very happy starting the mediation. And he asked both the other attorneys, who were both women, kind of about their family or news. And he did not give anybody the impression that he was hurrying us, even though he may have been watching the clock, to make sure it didn't go too long. But we did settle that case. It went 12 hours, a very long mediation, very difficult case, very contentious case with a history and difficult parties. But I think that meeting with the attorneys helped establish the tone of the mediation. And you can do that really as a mediator with any point. If you feel that the dynamic is right for it, you can set your breakout room, pull the attorneys aside, maybe discuss where you are with the process, and try to see, okay, we've got an agreement on 5 points. We've just got to get through these last two, and try to encourage them and keep it reasonably friendly. And I'm sure some of you have developed good techniques for doing that. That may be different than what I'm suggesting. Would love to hear what some of those are. I apologize. I'm very susceptible to Austin allergies, and something is hitting me right now. My goal, and I think a pretty common goal with most mediators, is to achieve commonality and commitment to the process as soon as possible. I really try to get people committed to, hey, we've agreed to all these things already. Let's try to do this. Let's try to wrap this up, and make them feel that they have achieved, they have made some progress in the mediation. They've invested that time with their attorneys, with paying the mediator, and let's make it happen. So getting people committed and believing that they're going to be able to do it, I think, is very important. Perhaps a little bit harder by Zoom, but you still need to work on that any way that you can, in the breakout rooms, in your caucus rooms, encourage people that they have made progress and try to work on those, the difficult sticking points that often emerge pretty readily in the mediation. You can see what they're, what's in agreement and what the sticking points are, usually pretty early in the process. This is a very interesting case, the Minix case that I've cited here. It is, the Minix case is out of the 14th Court of Appeals in Houston. And when this case came out, I remember at one of the family law section meetings, we were getting a case update, and there was a real difference of opinion about this case. In re Minix, the court held that the parties cannot agree to set aside the MSA once properly executed. Assuming disputed issues of material fact regarding whether the parties agreed or the judge pronounced from the bench that the MSA was set aside, the statute does not permit the parties to agree or the judge to set aside the MSA. Well, this is interesting because mediation is a settlement process. As I was talking about when we first went into settlement week and we hadn't had formal training in mediation, a lot of us were still used to having settlement meetings, which are not that commonly held anymore. But when I started practice in '87 and I had started clerking in 1985, we very often held settlement meetings, and those usually were just the attorneys. But some attorneys were very, very good at reaching agreements in settlement meetings, probably some of the same attorneys who are good at reaching agreements in mediation or in collaborative law settings. They're agreeable and they're problem solvers. So when you think of mediation as being in a process of reaching an agreement, and then the idea that both parties agree after the mediation to set it aside, then the court says, no, you can't do that. It is an interesting dilemma. And I think about the issue of, well, what if these parties are in a divorce case and they decide they're not going to get divorced? They've executed an MSA. So I suppose the solution there is to jointly non-suit the case, which would then remove the MSA. But this is an interesting opinion. I don't think we have the Supreme Court directly on point on this yet, and it will be interesting to see if they concur with the Houston court. The Diggs case is a case out of also same court, 14th Court of Appeals out of Houston. And in this, there were a variety of issues that were, brought up on appeal, one of which was whether the mediator should have been disqualified. And so there's a discussion in the case about waiver. If you've been told that this party, the mediator had actually been consulted, I think, by one of the attorneys about possibly participating in some way in the case. And when that mediator was suggested for mediation, that fact was revealed and there was no objection by the other side. But then it was brought up on appeal that the mediator should have disqualified himself. Anyway, the court overruled that point, that it had been waived, that objection should have been brought, well, obviously, ideally before the mediation ever took place. But the court did hold in the Diggs case that the parties must return to the mediator for arbitration if required by the MSA. And the court was not willing to take up the case with that provision and sent the parties back to the mediator for arbitration because that was what they agreed to at the time of the mediation. This also, the Highsmith case, is an interesting case as well. These parties went into mediation before suit was ever filed, and they reached an agreement. Of course, there was nothing to, there was no case, an underlying case to file the MSA in yet. So there was a written mediated settlement agreement between the parties. Subsequently, the case was filed, and then one of the parties went in to do a prove-up based on the MSA. And the Supreme Court held that the principal issue in this case is whether an MSA that resolves the parties' property division and conservatorship issues can satisfy all statutory requirements if it is executed before a petition for divorce is filed. Unlike the Court of Appeals, we hold that it can. The Court of Appeals had held that the suit hadn't been filed yet and that that was a necessary prerequisite, and the Supreme Court said, no, it's not. If you think about a civil litigation, a non-family civil litigation where parties may have gone in and resolved in mediation issues that would have been filed, would have become litigated issues, it would shut down those cases from ever getting filed. So the interesting thing with a family law case is you reach an agreement pre-litigation, but somebody still has to file suit. And so this case, it did get sent back just because the court held that one of the parties to the MSA didn't receive proper notice of the hearing at which the trial court rendered judgment. So they reversed the Court of Appeals judgment in part and remanded the case to the trial court for further proceedings. But one assumes that what that's going to be is rendition pursuant to the MSA. So this was interesting, that a pre-litigation MSA is still binding after the case is filed subsequent to mediation. In the interest of CNH, and this case is pretty recent, February 5th of 2020, and it involved a case where after the mediation, there was a hearing about domestic violence, and the parties had agreed to be joint managing conservators in the MSA. The trial court held that because there was a finding of domestic violence, they could not be joint managing conservators pursuant to the Texas Family Code and would not honor that provision of the MSA. The mother was appointed the sole managing conservator, and the father was appointed as the possessory conservator and filed an appeal. So the court held that the trial court was required, and they quote section 153.0071, to enter judgment on the MSA, absence of finding that a party to the agreement was a victim of family violence, and that circumstance impaired the party's ability to make decisions, and the agreement is not in the child's best interest. Excuse me. I apologize for the coughing. Now, we looked at a case earlier, the Lee case, where the court said you can't, the appellate court said you can't make just a broad best interest determination to override the MSA. And here is again another situation. The court upheld the MSA, that the court didn't make any findings that would have been, it says, would have been unsupported by the record. The trial court abused its discretion in declining to enter judgment on the MSA. And they're talking about this requisite finding that a party to the agreement was a victim of family violence. So even though when you read about some of these cases, you suspect, well, there may be future litigation, at the time of entry, again, you see the court over and over again upholding the MSA. Probably many of you do this. I suggest preparing a draft or a shell MSA before the mediation starts. When we first started doing mediations broadly in Travis County, we didn't have these, and I was finding, both when I was mediating as well as when I was representing a party at mediation, that drafting the MSA was just taking forever. And of course, you know what an important document it is, because if something is left out or if something is not clear, then the parties are coming back either for mediation or arbitration, or they're going to the courtroom to try to figure out what they meant or to get some judgment on the MSA. So if you're new to mediation, then, sorry about that. If you're new to mediation, then I do suggest that you borrow from a friend, borrow from a fellow mediator, use the Texas Family Law Practice Manual forms, or pro se materials that are often available on the district court website or in Travis County from the reference library, which has some really excellent forms that you can use to pattern off of and save time to check off to make sure you haven't left off important rights, privileges, and duties. I think that is especially important if you are mediating with pro se parties. The attorneys should be pretty good at realizing that they need to get all their terms in there, and you will have their assistance in making sure that it's complete. But with pro se litigants, that may not be the case. So having the full checklist so you don't leave off anything like the right to make educational decisions or the right to determine the residence of the child and whether there should be a residence restriction. These are things that are super helpful and time-saving to have in a checkoff form. And that's really kind of saying the same thing, that you must make every effort with the help of the mediating attorneys to prepare a clear, enforceable mediated settlement agreement. That is what the court is going to be looking at word for word if there are disputes about the MSA. The Milner case, which is also a Supreme Court case from 2012, the court cannot read terms into the MSA if the language is ambiguous. So if there is a true ambiguity, that is the sort of issue that is going to require either adjudication by a court or the case being sent back to mediation or arbitration, depending on the language of the MSA. And so this had to do with some limited partnership rights, and there's an extensive explanation of what the differences are and what different interpretations there might be. So the court did find there was a true ambiguity in the MSA, but the Court of Appeals could not substitute its reading of the MSA for that of the trial court. But the Supreme Court held, but neither was the trial court the appropriate authority to resolve the dispute. The MSA provided that the parties were to return to the mediator in the event of a dispute regarding the language in the agreed final decree or other documents necessary to effect the MSA's terms. So the mediator, rather than the trial court, was the appropriate authority to resolve the fact issue. Again, usually quite a bit of consistency in the courts about this. I'll show you one case where a different result happened, but it's definitely the anomaly. And it's this one. This is this case, In Re EWM, and this is a case out of the 5th Court of Appeals from Dallas. The parties and their attorneys came into court and they waived the arbitration under the MSA and asked the court to decide the disputed issue. And the record, which is partially quoted in the opinion, it sounds like, I mean, both the attorneys and the parties were just sort of begging the court to please decide it because they didn't want to go back to arbitration. And this is interesting because other courts of appeals have held that you agreed to arbitration under the MSA, and that's what you're doing. You're going back to arbitration. But in this case, the trial court held that under the MSA, the arbitrator, and thus the trial court sitting in place of the arbitrator, had the authority to include language to effectuate the intent and agreement of the parties. And if my recollection holds, the parties were disputing language about a right of first refusal, which if you have ever drafted any of those in mediated settlement agreements, they're very problematic. As a practitioner, you know, I don't often favor them because of the difficulties of construction and enforcing them. But there was a shorthand used that the other party, each parent had the right of first refusal if the other parent would not be able to supervise the child overnight. Then in the different versions that the two attorneys prepared for this, they had both added terms to flesh out the right of first refusal. But I think Mother had added that it wouldn't include sleepovers with friends or sleepovers with her family members or sleepovers with the father's family members. And the parties both said, we want you to decide. And the judge decided in favor of the language that mother had suggested, and father didn't like that, so appealed. But in this case, at least, and this is the only one of the recent cases that I've found this in, the trial court kind of let itself be talked into sitting in place of the arbitrator. But most of the other opinions order the parties back to the arbitrator or the mediator to serve as arbitrator. Here we goes, another one. In re KAM, and this is a case from the 12th court out of Tyler. Parties were sent back to the mediator for arbitration per the MSA on discrepancies between the MSA and the decree. And I don't know that if you do just mediation and are not a practicing attorney helping with the drafting, the decree or the order, from the MSA, you may or may not be aware of how often there are occasions to deviate from the exact language of the MSA. And I had this happen recently in a case that we did that was out of Bastrop. And there was a delay of about 3 months between the filing of the MSA and our being able to enter the decree. And the reason was that there was a house that was on the market. It was below market. So the parties were going to have a deficiency on the closing. And we had a realtor who was going through a lot of creative machinations to try to get these people out of the, get the sale of the house to go through without both people having to bring money to the table. So we did have to slightly reword by agreement some of the language about payment of expenses for the house. I think had the parties not just agreed to this, both attorneys agreed and the parties both agreed, and the issue had come in front of the court, I think the court would have had to change it back to the exact language of the MSA, even though it was after the fact and the father had not followed through. So I think in these cases where the dispute is coming before the court really has no choice but to, honor and uphold the MSA. And so the KAM court held that there's at least one dispute regarding the interpretation of language between the MSA and the final order that triggers the arbitration provision in the MSA. Thus, once the trial court became aware of a discrepancy between the MSA and the final order, it should have ordered the parties to arbitration by the mediator as agreed to by the parties in the MSA. This really seems to be the consistent finding of the trial of the appellate judges, is that if this is what you agreed to, then this is what you need to do. And only in that one case that I've found so far did the court allow itself to be put in the role of the arbitrator. So raises that issue again of this needs to be explained to the client. The client needs to understand what the process would be, and that the court will probably not be involved at all if the arbitration provision is in the MSA. Okay, well those are the PowerPoints that I prepared for today. So I'm going to, for the moment, pull out of this PowerPoint and see if we've got any questions that have arisen from what I've been talking about, and questions or comments that you would like to share. I am very interested, and you may have already discussed this as a group before, about what you're doing during the pandemic to kind of make it work by Zoom, what adaptations you've made in the way that you mediate to kind of get people to move along and establish, a little bit of bonding as they go through this process, since we don't have them live and we can't ply them with baked goods and donuts and good coffee and lunches and things to kind of cheer them up a little bit as they spend their many hours of the day, trying to go through this difficult negotiation. But I am open for questions right now. If I think Thea maybe was looking to see if any had come in the chat. I don't know if we've had any or not.
Hi, yes, thank you. There was something that Gary put in, and I thought maybe Gary, if you're able to, you might just unmute and say what it was that you, I'm not sure if it was a question or a comment.
Well, it's actually a question. Thank you. And it has to do with more about the relationship between being a mediator and being an arbitrator. There were several comments made in your presentation here about things like binding arbitration with the mediator was one comment. Mediator serving as an arbitrator was another one. I'm wondering who determines that, and what do you need to do to be an arbitrator? Because many of the mediators here and elsewhere have not done any arbitration before.
Yes, and it's a good point, Gary. I mean, the mediated settlement agreement is where that language usually occurs. And what I see more typically, at least when I am a participant, an attorney participating, is that the mediator is agreeing to resolve non-substantive disputes. And it will often say, by the reference to the Family Law Practice Manual, we're going to defer to that to try to break any disputes about drafting. But others say any disputes arising under the MSA. Now, you do raise an issue. I know that when we prepared our directory of mediators and arbitrators that belong to the ADR section, very few of the mediators were also trained as arbitrators. And that may be a bit of an ethical dilemma there too, because I'm sure there are some mediators who are resolving these disputes as an arbitrator without that full training. Sometimes the language says that we'll return to the mediator for mediation or arbitration, and you can draft that language in a way that you are comfortable with it. For example, if you have an MSA and you are not a trained arbitrator and you feel uncomfortable putting yourself in that role, even if the parties want you to do it, you can say that they would return for continued mediation. In that case, I mean, of course, if there's an impasse, then I think they're going to have to do, a motion for entry, or if they just didn't reach an agreement at all, then I guess they're headed for either another mediation or for litigation. But the issue of, can a mediator arbitrate a dispute over the drafting or the substance of the MSA, if not a trained arbitrator, I do not know the answer to. One would think it means, yes, you have to have arbitration training, but I do know many good mediators who are doing this who are not trained arbitrators. So it may be that that's definitely, a point that needs to be looked into. And if you have a discomfort level in serving in that way, then I'd say make sure the MSA does not have language that you're uncomfortable with. I've been asked as a mediator, you all have probably been asked a variety of bizarre things that they would like you to decide too, most of which I refuse to do. I was recently asked by two very good board certified attorneys, would I like to select the child's school? I'm like, I most certainly would not like to do that. I don't know the child. I've never met the child. I'm going to defer to the parents and their opinions. I can help with a mediation if they want to put together their fact list and come back. But no, I mean, sometimes you're asked to do things that you really shouldn't do and that you're not comfortable doing. And those you just have to say no on, I think. I would never want to be the decision maker on something that was as important as a child's education without even knowing the child and any of the circumstances, from that child's perspective. But you raise an excellent point, Gary. I'll try to find out the answer to it too.
Thank you.
And we have another question. Susan sent a question asking, is the revocation statement used in mediations when both parties are pro se?
Is the revocation. It has to be used in everything if it's going to be a binding MSA. And mediating with pro se folks is very challenging. I don't usually do that personally because I'm very concerned about the ability of the parties to have legal advice and can't give it to them myself. And people have all different, ways of dealing with that situation. When we've been doing the courthouse mediation project, I have mediated some cases with pro se individuals at the courthouse, and they have been, in one case, very well prepared on their own with materials from the reference library. And in another case, not well prepared, language issues. And it really, I don't think they're, I wasn't comfortable in mediating in that situation. But yes, that language of irrevocability needs to be in there if you're mediating with pro se parties too. If they're reaching a binding MSA, and they do have the right to do that without counsel, it's tricky. But yes, that language needs to be in there. That is the language that every one of these courts goes through the recital of checking if it's an enforcement issue to see. Have the parties done that? And then if they're checking off the boxes, they're going to, again, they are going to bend up over backwards to try to uphold that MSA, just to continue to encourage mediation. And really, if we had too many opinions knocking down the MSAs, it would, greatly reduce people's interest in trying to resolve disputes that way. So making it hard to attack an MSA, I think, is good for all of us and for the people who committed to the process, who, like I said, I had a 12-hour one in January, 12 hours paying to each attorney, 12 hours paying to the mediator, substantial time and financial commitment, so you don't want to be able to knock something like that down without very, very good reason.
Thank you. So there haven't been any other questions typed into the box, but I know that Sarah had been interested in finding out what techniques people are using for breaking the ice and building rapport with online mediations. So perhaps anyone would like to chime in on that before we finish up.
Yes, I'd like to know if there's any substitute for donuts and good baked goods. Those usually work pretty well for me.
Feel free to unmute. We're at 1 o'clock. I know Sarah said she has a few minutes to stay, but if anyone needs to leave, that's completely understandable. We realize we're all maybe on lunch breaks and whatnot. And I believe we are, there we go. Alyssa just put a Survey Monkey in the chat box where you can just let us know how the presentation was for you and any suggestions you have for future presentations. But I would say at this point, feel free to unmute if you have other questions or comments for Sarah. We have a few minutes.
Susan, did you have a question, or were you just, I couldn't tell if you were raising your hand. Okay. I do see a few more familiar faces now than I saw at the beginning. And
I'm sure some of you all have techniques that you've used for online mediations for making connections with the clients.
We've talked somewhat among ourselves informally about, is Zoom mediation just as good? Is it better? People have different opinions about that. I mean, I practiced a long time. For me, in person is better. I just feel like I can do my job better. But there are some advantages to doing Zoom in terms of, transportation savings and that type of thing. And it also makes it possible for people in domestic violence situations to mediate effectively, because they can be kept in a separate breakout room and never have to see the the perpetrator. So I think hopefully that's something that will be able to be used in mediating domestic violence disputes in the future. But if you do have any tricks you've found work, again, I'm sure the group would enjoy hearing what those may be. And for many of us, it may be that we've managed to master it well enough to do it at all, and to make a breakout room, and to not disconnect people when we're trying to shift back and forth. I've certainly participated in my share of mediations with the technology problems by Zoom, as some of you probably have too. And even with very good mediators, one of the ones we did early on, the mediator kept having to shut down the whole Zoom room when she went back and forth, and she was texting us by phone. But it worked. We got it done. We got the case settled. So we've all had to make some adaptations. But yes, Robert, did you have a?
Yeah, I do have, I don't have a comment, but I do have a question. And I apologize for being 30 minutes late. For whatever reason, I had this at 1 o'clock on my calendar. And fortunately, I looked at 12:30. So you may have addressed this, or this may not even be part of the topic, but I do all my mediations at the DRC. And I do all, for the most part, civil litigation mediations where there are attorneys. From the beginning, I've never participated in the drafting of a settlement agreement. I always let the lawyers do it, and then I'll facilitate the back and forth if they're trying to figure out language or this and that. But typically, the lawyers are figuring that out. Am I neglecting part of my responsibilities here by not being in, not writing a mediated settlement agreement, or not participating more directly in it?
No, I don't think so. As long as the parties or the attorneys that you're dealing with are comfortable with that, there's nothing wrong with that. Many of us in the family bar have real control issues about wanting to draft the order. I mean, I would always prefer to draft the order if I have my druthers. And in many ways, it ends up being more efficient than trying to have to critique another person's order and then request changes, etc. So in the family law bar, I know as practitioners, we don't usually want the other person drafting it. We want the neutrality of the mediator. And so in my cases, both when I mediate as well as when I'm participating, I am usually doing the drafting. Now, both of the attorneys have input on that, and we pass it back and forth, and they can edit it, and they can add provisions and all of that. But, and that's why those kind of shorthand forms are tremendously important, because if you're having to draft from scratch all the rights, privileges, and duties of parents, it's very time consuming. So, but if you're drafting general civil disputes too, I mean, many of those center, I assume, around money, payment of money. They may not have the same, I mean, the parent-child cases have such complexity that it really is easy to leave something out, especially if you're dealing with pro se people. And I can't imagine having a pro se person draft it. I mean, I remember years ago with one of the Williamson County settlement meetings, we again had kind of limited resources, and I literally just wrote it out by hand, and we put it in the record and filed it. I think that's the only one I've ever just written in handwriting. But and of course the other side, like, oh well, that's handwritten. It's like, well, it's still binding. It got filed, it got signed by everybody, and we held a difficult case together. But no, I mean, if the attorneys that you deal with, and you said you're pretty much dealing usually with people who are represented by counsel, if they're comfortable and familiar with that, I see no problem with that whatsoever.
And I would say the majority of the cases at DRC are family law cases. I mean, we do get other types of money disputes or contract disputes, as you mentioned, but they seem often they've either prepared one, or I've asked them to prepare one when they're, when I go to the other caucus room. So, okay, that helps. I just, I've always avoided it.
Well, and that's fine. And as long as that other attorney is getting input on the drafting of the document and isn't feeling like somebody's got the upper hand, I think you're perfectly fine in doing that. Okay. I don't see any ethical issue there at all. It's just most of the cases I'm dealing with, there's the expectation that the mediator is doing it. And so you want to make sure that you get a head start on it, if at all possible. At least get your little cover sheet done and get the parties in the case in there, so you can kind of move it along. I just remember when we first started mediating, it was sometimes taking hours to get the MSA put together, and people lose patience, and then they might just say, hey, forget it, I'm not going to do it. And that's what you don't want to have happen.
Okay, thank you.
Oh, sure.
Thank you, Sarah. And I know that you had a time limit, so I want to be sure to respect that as well. So I just want to say thank you very much. And I think a lot of your points were really right on for what a lot of us needed more clarification on. So I really appreciate you talking to us today. And I imagine people probably have other things they would love to reach out to you about to follow up. So I think it's really great to have you here talking to us today. Thank you very much.
Well, thank you for the opportunity. I've enjoyed it and would have loved to be doing it live so I could shake people's hands and make sure I did recognize them the next time I saw them on the street. That's just really a question I have with Zoom. You just see this little headshot, and somebody may have their hair a different way or a different color next time you see them. But anyway, I hope to get to meet all of you in person at some point. It's a great organization and one I have always intended to join. So I will, renew my efforts to follow through with that and join this excellent group as well. So good luck to everybody in their practices.
We're getting there've been lots of people saying how helpful it was in the chat. So I don't know if you're seeing those.
Good. Oh, good. I hope so. If you can carry even one useful piece of information away, that's a good topic for, in my opinion, any little tip that you can actually implement. If it's one or if it's more, that's great. So thank you.
So everyone, please, if you can find that link that Liz had sent out a few minutes ago with the evaluation. It's this pretty short evaluation, so that's really helpful. That's really helpful for us. And thank you all for coming today. Have a great rest of the day.